This is the FM Gold channel of All India Radio. In the program Money Talk, we now bring you a dialogue on New Companies Act. The participants are Maithili Bhusnurmat, Consulting Editor, Economic Times, and Jaimini Kumar Srivastav, Business News Analyst.
With the President's nod to the new corporate law and it coming in the Gazette notification, now it's clear that the country is having in place a historic companies law, which is at par with the international standards. What are the key features, Maithili, in this law which you think in the long run will pave transparency in Indian companies' performance and will increase their credibility, and also the fact that in terms of international cooperations between industry to industry, this will prove to be a milestone?
Well, generally, any piece of legislation must keep pace with changing times. The earlier Companies Act dated back to 1956, and though that is not very long ago, considering that we have a number of legislations, even if you look at land acquisition, which is currently in Parliament, 1894, so by that standard, 1956 was not all that long ago. But even so, since there has been so much of development, particularly in terms of technology, etc., there was a need to replace the earlier now, in fact, one should say, the earlier Companies Act with a new one. So, in fact, one must actually congratulate both the government as well as the opposition, because for once they've actually got a good piece of legislation through, unlike in the case of populist measures where they invariably come together, and everything otherwise where there's economic logic, opposition and the government never see eye to eye. So this is one piece of legislation at least where they come together, and there are a number of changes in the new Companies Act in terms of definitions, in terms of enabling provisions. Like take a case like because of electronic development, so much progress in the electronic area, so now you can have e-voting, you can have video conferencing of the board of directors meeting. Then similarly you can have electronic maintenance of books in electronic form. So these are all the changes that have been introduced in the new act. I mean, it's a huge act, so it's very difficult to really sum up the entire thing, but very broadly, if you
more
look
than
at
100,
yes,
close to 200 recommendations were there.
Because there are now 470 new clauses as against 658 sections, and the earlier act had been amended 25 times. So this is a new act which completely does away with the earlier act and puts in place a new modern legislation. The first is in the course of definitions. A number of definitions have been redone, some items have been junked, some new definitions have been incorporated, they've been made more clear. Then in the area of mergers and acquisitions also, the whole process has been made more simple. Audit and auditors, their roles have been clearly specified. CSR, the entire concept of a mandatory corporate social responsibility has been introduced. Then the role of directors, independent directors has been elaborated on.
But they're fixed on. That's very important.
Yes. And now you have a new companies tribunal, so unlike earlier where you had to go to the court, now you have a new companies law tribunal. Then you also have greater emphasis given to investors protection. So there are a number of areas, and these are just a few that I have kind of dwelt upon. But the whole purpose of the act is first to make it easier for corporates to do business, and at the same time to also ensure that investors are also protected.
It is said that close to 75% of the provisions will need rules to further bring it into practice. So there is another important exercise left, and it seems the Ministry of Corporate Affairs will be seeking people's comment before coming on with those rules. So in effect, it may take a couple of more months perhaps to see that this new corporate law is put into practice.
Absolutely, because the framing of rules is a very complex exercise. But in a way, I think this is good that all legislation, if they follow this practice, it would be good, because rules, if you have to keep going back to Parliament to make an amendment, it becomes much more cumbersome. So it's always better if the nitty-gritty, the finer things are put in the rules, which can be changed through executive fiat, or the administration can do it, rather than having to go back to Parliament. Having said that, the framing of the rules is a very complex exercise. It will take time, and it's good that the government has decided that they will frame the rules after getting a feedback from the public. Because otherwise, if you frame the rules and then there are some objections that are raised, or you realize the rules are not feasible, they're impractical, then you have to again change the rules. So it is good that you frame the bare bones skeleton of the legislation, then you seek comments and frame the rules in consultation with experts. So the rules, one framed, you don't have to keep going back and forth. There is complete transparency, clarity, etc. So I think this is a good practice if the government were to do it for all legislations where you have complex rules. it would be very good, I think.
And this is the way you can involve almost the entire society.
Absolutely. And you can get a good feedback from those who know, the practitioners. Because after all, very often the rules that are framed, the law is framed by people sitting in law ministry, perhaps who are likely to have more of a theoretical knowledge, rather than the practitioners who actually work in corporates and know what are the nitty-gritties, what are the problems, what are the issues. So this is a good way, I think, to kind of go forward in any area.
Maithili, as you said that there are so many new features added to this law, making it very difficult to pinpoint which is the best and which is slightly less important. But nevertheless, corporate social responsibility is one of the issues which have been in the news, being talked about internationally. But as far as corporate social responsibility of Indian Inc. is concerned, there was nothing in place. There is a specific provision for that in this law, and I think which is going to be very important. How relevant you see?
Well, this has been quite controversial, Gemini, for the simple reason that there is a view that the corporate's job is to run the company successfully. A duty is to their employees and to the shareholders, and to run the business ethically. As far as social responsibility is concerned, that is something that government must do through taxpayer money. That is why I think there was a lot of controversy. So initially the proposal was to make it mandatory, and now it is not mandatory in the sense. It's just that the board of every company has to ensure that the company spends at least 2% of the average net profits of the company during the immediately preceding years. So there is no penalty as such for not doing it, but you have to report it to the board. And I think the idea is that companies that don't fulfill this obligation, there will be some backlash in terms of their valuation of their shares on the stock market. I think it is really, perhaps it should not be put in the law, even though you kind of diluted by saying it's not mandatory. Perhaps this is, social responsibilities was something that companies should do of their own, and without being compelled by law. And I think all good companies in India, all good corporates everywhere also know that they are also part of society. So if you need to have a good public image, then you need to do these things. Having said that, to the extent that it's not mandatory, but you just have to report to the board, I think the government has sought to find some kind of via media to see that the corporates also perform some of their social obligations.
Maybe on the advice of the government in the long run, or maybe on the expectations of the government, maybe on the basis of the trend at a given point in time, where some kind of help from the industry is required, maybe collectively or maybe individually. Perhaps this could, help in achieving that target, because as of now, there was no understanding in the minds of the people generally, commoners and those who are into corporate life, that yes, they owe something to society. It was perhaps merely limited to earning profits for the company, its expansion, maybe for its employees. Now perhaps it involves everybody, the employees, the nearby area where the company is located, or something like that.
So by extension, if you apply that logic to individuals also, there should be individual social responsibility also.
Exactly.
Because we pay our taxes, similarly corporates pay their taxes. So their responsibility to society as per law should end there. That's why very few countries have this concept of a corporate social responsibility enshrined in law. I think it would have been better if it was not enshrined in law, but as I said earlier, to the extent that it's not something that is absolutely mandatory and for which there are some penal provisions if they don't fulfill it, I think it's something like a via media. I think good corporates in India, we have the example of the Tatas, Wipro, etc., which do extensive work in terms of helping society.
There is also guidance in the sense that only companies reporting 5 crore rupees or more profit in last 3 years, as you said. The other important aspect which you mentioned about the special courts for speedy trial. So far now, there was always a problem how to take the disputes and how to reach to some kind of understanding conclusion. Do you think the only hitch is that there have been so many special courts? The issue is how you are going to have the judges appointed. There are regular courts, short of judges already there, and there is a mechanism of special courts, but how? Are these going to be set up along the side of the normal courts in the same campus with the same strength, one judge designated to be the special judge for these courts? Or there could be a separate provision altogether for these courts? That is perhaps a kind of nitty-gritty which needs to be worked out and clarified, because we cannot just presume that the number of disputes arising of the functioning in the corporate affairs is going to be very few and less, and some sort of a demarcation of a special court for redressal of such grievances will take care of it very soon and expeditiously.
Well, it is a fact that our legal system, there is a lot of delays. So to the extent that you have a special court, it might become faster than if it joins a normal track. But we already have special courts for so many different areas.
The intent is very good.
Yeah, experience has not been very happy. Having said that, I think together with the New Companies Act, which actually makes fraud much more difficult, has many safeguards, allows things like class action suits, I think that maybe you will have fewer disputes also, because companies also will be very much more wary, because they know that, well, they can't get away as easily as before. So hopefully the number of disputes will come down. Now that you have a separate National Company Law Tribunal, it will be faster. So the hope is that you really will not have so many disputes, together with the fact that many more responsibilities have been cast on directors, independent directors, including, mind you, there is a provision that companies of a certain size must also have at least one woman director, and there are certain obligations on the kind of auditors, responsibility of auditors.
Yeah, this auditors issue, how it was affecting otherwise without these kinds of provision, and what necessitated to have this kind of a provision where the number of companies an auditor can serve to 20, besides bringing more clarity on criminal liability of auditors. What in effect it means, and if it was not in place, how it harmed.
Internationally, in the case of Enron, and in the Indian context, the case of Satyam, where you found that you have the same auditor for a very long time, a certain kind of nexus, a certain kind of relationship develops between the company and the auditor.
An auditor has to be independent and transparent.
Yes, so the idea that you need to have rotation of auditors, so you don't have any kind of vested interest developing, that is a good thing. At the same time, limiting the number of audits that a particular audit company can take up. So that is also good, because then you have, your time is not frittered away, it's not spread too thin. You're able to go more deeply. So I think these kind of safeguards are very good. It ensures that the entire audit responsibility is seen more seriously by the auditors.
But the criminal liability is something which is very interesting.
Yes, it would perhaps, I'm sure many of these cases will go to court, because one can argue at where does one draw the line? Is the auditor's job, is he the policeman? How does he enforce it? After all, you can only audit what is shown to you. What is not shown to you, perhaps, or you're not aware of it also. Auditors will also say that to pin criminal liability, there's a difference between negligence. Ultimately, case law only will decide where exactly does one draw the line, where does the auditor's responsibility really end. So you also have the provision about the whistleblower, so that also will help, I think, because people who are doing audit will get the help of whistleblowers, because within a company also you do have a provision that somebody who wants to kind of report on the wrongdoings of the company from within, he or she will not be penalized. But as I said, we really have to see the rules, see how they actually act in practice rather than in theory.
1/3 of board of directors should comprise independent directors. You mentioned about to ensure transparency. Of course, industry has by and large already welcomed the provisions of the law, because it has come after many discussions. But will it be really, helping the company, because the number of independent directors will increase on board of the company?
Well, I think independent directors certainly add to the worth of a company, the value of a company, the discussions in the board meeting. If you have a board meeting which is packed with yes men, they are not really going to get any meaningful kind of proper debate on any issue. But having said that, independence is really a state of mind. And as long as the independent directors are appointed by the promoters, you're never going to get that. So I think that is why you have certain safeguards. You have a data bank for independent directors, and now you also have, there's a code for independent directors. So unlike earlier when independent directors could get away by saying that, look, we are independent directors, we really didn't know what was happening, we're not responsible for the operational matters. Now there's a much greater onus cast on independent directors also. There's also a limit on the number of companies on whose boards you can function as independent director. So I think the attempt is really to put some responsibility
on everybody.
But at the same time, you put too much responsibility, then nobody will want to be an independent director also.
Yes.
Because the responsibility is too much, and you say, look, I don't want to have anything to do with it, the company, but after all, at the end of the day, the day-to-day running of the company has to necessarily be done by the company insiders.
Perhaps the rules will clarify.
But there is a code for independent directors.
Yeah, but one quick word about the protection for investors. This is something very important from the point of view of the common man.
So there are a number of safeguards, I think, for investors. You have much stricter provisions for deposit taking, for instance. Then you also have a greater safeguard against fraud. You also have, the provision for class action suits we didn't have. In the case of Satyam, for instance, investors in the US were able to proceed against the company with class action suits. In India, we couldn't. So these kind of additional provisions will certainly safeguard the interests of ordinary investors.
Thank you very much.
You were listening to a dialogue on New Companies Act. The participants were Maithili Bhusnur Math, Consulting Editor, Economic Times, and Jaimini Kumar Srivastav, Business News Analyst. It came to you in the program Money Talk, produced and presented by the News Services Division of All India Radio. This program is also available on our website, newsonair.nic.in. You may email your opinion about this program at airnsdtalks@gmail.com.